Good afternoon, everyone, and welcome to part 2 of our Employment Rights webinar series. So it's great to see so many of you back with us after the first session. So welcome back. And for those who are joining for the first time, a very warm welcome. So you'll be able to follow along without having attended part 1, so don't worry if this is your first session. So just by way of introduction, I'm Phill Anderson. I'm the Global HR Director at Briars Group, and I'm delighted once again to be joined by Jonathan Rennie, Employment Law Partner at Level. So just before we dive in, a couple of quick housekeeping points. We'd love for you to have your cameras on if you're comfortable. Makes the session feel a little bit more like a conversation. And secondly, you're muted by default, but if you'd like to ask a question at any point, just raise your hand in Teams and one of our moderators will either unmute you or drop us a question into the chat and we'll get right back to you. So we want this to feel like a discussion rather than us just talking at you. So if something sparks a thought, please just jump in and ask a question. Okay, let's get started. So what we'll cover today. So first we'll set the scene on where things actually stand with the bill. We'll then look at the reform roadmap from 25 through to 27. Yes, you heard me right, it's through to 2027. We'll spotlight 3 of the biggest changes you need to be ready for. We'll share some practical steps you can take now to prepare, and then we'll wrap up with a summary and finish by showing how Briars and Level can navigate all this in practice with you. So in terms of just setting the scene as to where we are now. So from a HR and business perspective, employers are facing a moving target. So some reforms are already locked into law and others are still under consideration, as you'll all be aware, and there's still detail being written. That means we're working with both sort of certainty and uncertainty at the same time, and we need to balance 2 things in practice. So that's implementing the changes we know that are coming, so that's point 1. And then point 2 is staying flexible for the ones that are still being drafted and talked about in the news and in the press. And there's also that political angle that no doubt we're all aware of. You would have seen it in the news, and you've if you think about reshuffles can change pace and priority, that's something else that you need to think about. So Jonathan, before we get into the roadmap of what's coming, can you sort of help us cut through some of this for us? So let's talk about what's already nailed down and perhaps share what's still up in the air a little bit.
Sure. So the Labour Party manifesto set out the changes to employment law, which are enormous, mammoth, gargantuan. I can't think of other enormous words to use, but the last piece of legislation of this scale was the Employment Rights Act in 1996. So we go all the way back to the summer of 1996. The Spice Girls were #1 with Wannabe, and Paul Gascoigne was scoring goals against Scotland. So that's how long ago it was. It's about entrenching workers' rights. So if we think about the employer-employee relationship, sometimes think of it as an employment lawyer, it can be a bit of a tug of war. Where is the balance of power? And the balance of power after this new piece of legislation will be more in the hands of the employee or the worker. And in terms of this discussion, I'll probably just use the word employee rather than worker, but there's lots of different categories or status of individuals. So the slide's correct in that it says there's both certainty and uncertainty, but for those attending, that can feel like a bit of a lawyerism, or where does that leave us? The reality is that the Employment Rights Act, as it will become through royal assent, will be law within the next month. And that sets out all of the different changes that we'll discuss in part today. But what we're saying is invisible is the codes of conduct, the regulations, the statutory instruments that follow on the back of that. So the broad principles are clear, but what that looks like in practice will be subject to consultation. So I read somewhere that there might be as many as 80 consultations coming out in the autumn. I'm not very sure how many employers participate in those, because I can't recollect clients saying to me in the past that they've really contributed, but there'll be ones on things like day 1 unfair dismissal rights, which looks like it will happen in 2027, that may be really pertinent. So we can expect to see those developments coming out, which will really put flesh on the bones, if you will. So the House of Commons, I think, has passed the bill back to the House of Lords, and there's something called the Salisbury Convention, which means, because it's a third reading, that the Act will simply be rubber stamped. So for anybody that wants to, you can go onto the House of Commons or the Houses of Parliament website, and you can open up the bill as it is, which is sort of 350 pages. But yeah, an enormous piece of legislation, and we're just picking up two or three key issues today, but we can expect a lot of press commentary around it. So, for example, when Phill talked about the political reshuffle, which was Angela Rayner, who was the sponsor of the bill, resigning, at that point there was a feeling within the trade union movement representing employees that maybe some of these provisions might be watered down because she was strongly in favour of worker rights. And I think the TUC wrote to government, and this is all on the public record, saying, we insist that the government follow through in its manifesto pledges. So the Act is just about there. The codes of conduct and regulations will follow shortly afterwards.
So that's not necessarily just a 2026 problem, is it? That's changed before Christmas, isn't it? So we think about looking at it through the lens of HR teams, business owners, managers. We need to start engaging and thinking about this now then, don't we, Jonathan?
Yeah, so I mean, it's a learning process for all of us, including me, despite working in this area for 20 years. So I think the nature of the timetable, when we can look at the specifics of that, is that there's three main tranches of changes. So in October, upon royal assent, there's some changes that are to do with simplifying trade union rules. So as a quick overview, that's intended to enable trade unions to have greater access to members. So that might be a digital obligation on employers to provide details to unions of employees, a simplification of the recognition process. So if you're in a non-unionized environment, it might become easier for trade unions to step in and try and become recognized, because some of us on the call will know that that's quite a convoluted process at the moment. And certainly the previous government put in barriers to trade union recognition. So the October changes will only really affect unionized environments and are about simplifications. But I think the main tranche of changes comes in April next year, then October, and then 2027. So when I talked about the political change, there's the roadmap to implementation sets out these broad timelines, but it might be subject to change. So for example, the final phase, I think because that can be coming to the end of a parliamentary term, there's a prospect of some of those later changes possibly slipping. But the main thing to note is you can print out this, as I've done, the roadmap to implementation, and just have an awareness of the key milestones and pick out the things that matter most to you and your organization. So I guess the priorities for different employers might be slightly different. The nice ones, if I can use that language, as a recent dad, is April 2026. We can see there's day one paternity leave and day one parental leave. So removing the qualification periods for that. I think parental leave gives up to 18 weeks of unpaid leave for a parent until their child is the age of 18. And the paternity leave, either 1 or 2 weeks, the qualifying period is removed. So there is a flavour of family-friendly legislation that we'll talk about in a little bit being improved and bolstered. And I suppose across the last number of years, family-friendly rights for staff have improved. Some employers are using that as a recruitment tool and obviously going above and beyond statutory levels. And of course, if employers want to do that and want to get ahead of the game, then why wouldn't you just make that change now? I suppose, practically speaking, it might just involve changes to policies and procedures. There might be a cost attached. That's one of the first changes. And then the establishment of the Fair Work Agency, which don't know, sounds a bit kind of 1984 George Orwell, but I think that's about national minimum wage policing and ensuring there's a stronger framework for enforcement for some of these breaches. So for example, I was looking at national minimum wage last night. and there's like a naming and shaming list, but I think sometimes that doesn't go far enough. So yeah, April 2026 changes to some of those pieces. The collective redundancy protective award goes from 90 days pay to 180 days pay. We can talk about collective redundancies if anybody wants to, but that's where more than 20 people are being made redundant at one establishment. So some of these thresholds shifting, I mean, that's a really good example of something that's favourable to employees, because the protective redundancy award is uncapped and is gross wages. So, you know, if the rules aren't properly followed, 180 days is half a year's pay, and if you multiply that up, it's obviously expensive. So that's sort of 6 months away. I'd say October 2026, the fire and rehire, abolishing that. We'll look at that in more detail in a moment. There is some planning about that, so I'm slightly jumping ahead from the substance of our chat today. But for fire and rehire, if that's a tool that you use for varying contracts, the top tip really is to have a variation clause in your employment contracts already and before October 2026, because after October 2026, it'll become much harder to vary terms and conditions under the threat that you will dismiss anybody that doesn't accept. So these things probably in isolation are little tweaks to policies and procedures. Fire and rehire is a strategic tool that not all organizations use. Some organizations use it before going through redundancies. And yeah, I suppose it's a catchy title, fire and rehire, but it's basically dismissal and re-engagement. So trying to change terms and conditions. And then the final phase in 2027, which feels ages and ages away, the day one unfair dismissal protection. So I don't think it was appropriate to go through the history of this bill through Parliament, but that was the Labour manifesto pledge. I think when it went to the House of Lords, there was a suggestion that this day one principle might change to a 6-month qualification period, but it is retained in the final act as being day one unfair dismissal protection. And the suggestion, and it's a suggestion because consultation and codes of conduct and regulations will follow, is that in the first 9 months, there might be what's called a light touch process. So for me, and for many people in the call, that's just such an enormous change. It's difficult to visualize how that works in practice. And in fact, it only occurred to me yesterday that if employees get day one unfair dismissal rights, there's a bigger prize for people that are classed as contractors or workers to try and get that right, to try and argue that actually they're employees because they get that protection. So I think there's a lot of thought that has to go into that around contracting frameworks if you have a flexible labour model and you use different types of worker. And yeah, at least there's time to get involved in the consultation and to think what that looks like. But essentially, from my perspective, it means that people that are on short-term gigs or assignments might well be able to sort of argue that they're employees from day one because they have the attractiveness of that protection. And then 2027 expanded protection. So it's slightly odd that, say slightly odd as a man, but the paternity protections look to be coming in April 2026, and the maternity protections look to be coming in 2027. So I've only just observed that just now, but we'll talk about the expanded protections for pregnant workers in a moment. And of course, generally, all organisations know how to deal with family-friendly legislation. So some of this will just be an endorsement of good practice or maybe what you do already. But I think the route map is worth having. It probably helps a real focus on what the priorities are for every employer. And listen, it is a really good document. We've not just copied it in here, this is the highlights, but it sets out, if you like, the cultural piece around what this legislation is looking to achieve. And, you know, sometimes that will feel a bit worthy or a bit enthusiastic for employment rights, but I think you can genuinely see that this is a major piece of legislation from the Labour government, and you can see the intention of how the different pieces fit together. So for me, really nice to see the extension of family-friendly legislation. There is going to be strengthening of harassment protections, which we'll discuss around non-disclosure agreements. And then the simplification of the union rules, I've kind of glossed over that because it's quite a technical area, but we might see some trade unions using this change to be more pushy, if that's the right word, on trade union recognition. So yeah, that's the roadmap, which means that we're not super overwhelmed with all these changes hitting immediately. And I would say that really, it's the period from after Christmas that we can expect to need to take a hard look at these.
I think that's the key, isn't it? I suppose the key takeaway for me is it's not just a one-off project, like you say. It's almost like a drumbeat of change through to 2027, and I think you just used the correct word there, as in it's a huge cultural shift, isn't it? That we're going to be experiencing, and for the better. I might add, it feels like a bit of a cultural reset for a lot of these policies, a lot of these frameworks, and I think the employees, as you said, are going to feel these changes directly as a result of those changes as well, aren't they?
And I think the politics of employment law is difficult for me to unpick that because I've worked in this area for so long, but there's frequently incremental policy changes to employment law in the last 10 years, particularly around family-friendly stuff. And so I think HR teams and sitting in senior management meetings might be saying there's changes ahead, and potentially people in those senior management meetings just see that as business as usual because there's always change in employment law. But I think that's again why this roadmap's helpful, because it sets out really clear deadlines and timelines, and it shows the breadth of it, which is huge. And there's areas that we haven't even mentioned because of limited time. So it's easy for me to say I don't sit in these meetings, but I like to think that HR people have the power in those meetings to say, look, significant volume of changes, significant number of projects. These are things that we need to have the resource for.
So here's one for you, Jonathan. So do you think businesses are underestimating this? I suppose seeing it through the lens of it's just a box ticking compliance exercise, when actually, using your words and mine, it's actually a bit more of a cultural reset.
I think it's going to be so prominent in the news because it's the Labour Party's key legislative provision. That there will be some organisations that they don't have HR teams that will struggle, I would imagine, with some of this. So, for example, where we talk about stronger worker rights entrenched and we talk about sexual harassment protections, again, because I'm also layering up my knowledge, we had the Worker Protection Act in 2024, which looked at the preventative duty for employers to protect staff from sexual harassment. We now have changes to NDAs, which we'll talk about. And then I think one of the October 2026 changes is that employers need to take all reasonable steps to prevent sexual harassment. So you can see a real tightening up in that particular area. So I think it's possibly the case that because the Equality Act came out in 2010 and is so huge across like 9 protected characteristics, that that framework of protections has been set for such a long time that sometimes these additional pieces can feel like bolt-ons, but they are pretty fundamental, particularly in the area of sexual harassment. So there's work to be done for sure. And as usual, it's standard. If an employer has a policy that's not up to date, referring to the particular pieces of legislation, it looks like there hasn't been an awareness of this. So yeah, the previous slide talked about employment tribunal claims increasing, which is at a time when the tribunal system is really, really creaking, and that's anticipated by ACAS, the tribunal service, who are going through recruitment processes just now. So I don't necessarily think employers are underestimating it, but yeah, the tightening of the framework and the way in which it's connected across different pieces of legislation can make it slightly complicated.
just picking up on your points in regards to the ACAS position and view on increased tribunal claims.
Yeah.
Have we seen that get better or worse over the recent months? So I think if we reflect on the first session whereby we sort of briefly touched on it, I suppose the view and thinking at the time was actually, like you were saying, it was creaking, there was too many claims, not enough people to sort of deal with that sort of stuff. If you drop in an additional 20%, maybe conservative number of claims on top, that's not going to be great, is it?
So I think the Employment Tribunal Service in England and Wales has just recruited 150 extra lay members, and as it has increased the numbers of judges. To be honest, I think you'll find employment lawyers are users of the system, and sometimes don't want to be critical of it because they have a little bit of a fear that will be deemed to be negative, or maybe they have a fear that they're in the tribunal system and a judge has an awareness of the criticism. But Casper Glynn, who's the King's Counsel and the head of the Employment Lawyers Association, has produced a document saying, it can't be that there's fair access to justice where an employment tribunal is heard two years after the event. And that is the case, particularly in the London and the Southeast regions at the moment, maybe not so bad in Scotland. But I think the change this year has really been seemingly the ACAS haven't been able to handle the volume of pre-claims conciliations either. And that's news to me because essentially, as many people know, ACAS act as a go-between or a facilitator for settlement between employers and employees. And we've had scenarios where ACAS just haven't been able to deal with a case within the month's conciliation period. So there's different ways of looking at it. I mean, there'll be lots of people that are frustrated about this. I did attend a barrister session where he was saying, well, there's a finite level of resources, and if we were choosing where money goes to, NHS, road, energy, defence, probably tribunals would be low down. But for service users, I think it's really poor, and I think it's favourable to employers who can potentially slightly manipulate the situation by knowing how long it will take.
Just a quick note in the chat: if you reach out to ACAS early conciliation, currently I've not had less than a 45-minute wait, and I find them more and more being really challenging about whether or not to accept an employer-led employment claim.
Yeah, I mean that's the way of it. Also, a slight oddity I find with conciliation is that it seems an individual claimant can just phone up and say that they want the conciliation to be concluded. So we definitely have scenarios where employers haven't been part of the conversation, and the ACAS certificate's been issued, which then enables the litigation to proceed. So yeah, a good ACAS conciliator is worth their weight in gold because obviously they facilitate dialogue, assist smooth things over. They can present the message in a good way. It's difficult, particularly with unrepresented claimants, for employer solicitors to be in touch with them in a way that doesn't look like you're trying to, gain one-upmanship or sort of over-lawyerize things. So yeah, I don't know what the answer is to that. I suppose this might come out in the main subject matters, but easy to say. But bolstering internal processes on disciplinary and grievance, we know that there's going to be longer time limits for people to raise claims, which we talked about last time, being from 3 months time limit to 6 months. So if there's extra time for claims to be lodged on one reading, there might be more time for employers to deal with things internally, and I know that presents extra pressure.
Okay. Thank you for the question. So let's just zoom in on the big three that we talked about at the beginning of the session. So no doubt we're all reading about these in the news. So I think Jonathan touched on them earlier on. So NDAs, fire and rehire, and family leave. So I suppose starting with NDAs first, Jonathan, they've been pretty much everywhere in the press and news, haven't they? What's actually changed? And I suppose for the benefit of those on the call today, what do we need to consider and think about?
Yeah. So I was just thinking about it there when we had COVID and we had the word furlough and it happened overnight and everyone was talking about furlough, and as an employment lawyer, it wasn't a familiar term, and I think NDA is a term that's bandied about in the press following the Me Too movement and Harvey Weinstein. Whereas lawyers working in this area might refer to them as confidentiality clauses or gagging clauses. So a non-disclosure agreement can have two elements to it. It's a requirement for an individual to enter into a confidentiality obligation where they won't disclose anything about the terms, facts, circumstances, amounts of money paid to them to settle a claim. And it will also potentially have an extra limb, which is a requirement that the individual employee doesn't make derogatory or disparaging statements against the employer. And I suppose the interesting thing for me as a practitioner is that these clauses have been standard for 20 years. Now, there's a link in the slides to the Can't Buy My Silence internet page, which is Zelda Perkins, who's a campaigner and worked for Harvey Weinstein. And she's campaigned and pushed for this change in the law, and it's described as a world-leading change in the UK, although it does follow on from a similar provision in Ireland. And it basically bans non-disclosure agreements insofar as they prevent an individual from raising Equality Act issues. So no doubt there'll be headlines about NDAs banned, but it's simply a carve-out from the general rule of confidentiality where somebody wishes to talk about discrimination or harassment under the terms of the Equality Act. So the reason I said this is a standard term is because I realized in listening to Zelda Perkins that lawyers just say that this is standard, this is template, this is boilerplate. And actually the development in the last 10 years or so is around the morality and the ethics of these clauses. So as lawyers, we've been used to implementing them. But the change is to ban the enforceability of confidentiality clauses around harassment and discrimination. So again, because I've been working in this area for so long, I remember 10, 15 years ago, there would just be like a bold confidentiality clause in a settlement agreement or a contract of employment or an ACAS Cat 3. And it would just say the employee undertakes to keep the terms, facts, circumstances confidential. And it would just be generally accepted. An individual's being paid a sum of money to waive a discrimination claim, age, race, sex, gender, disability, whatever it might be. But then in the last 10 years, there's been carve-outs for things like to report an offence to the police, for whistleblowing disclosures, to report a criminal offence. So nowadays, I printed out the style here, which I'll try not to read, but the confidentiality clause has as many as 10 different carve-outs. So on one reading, the carve-out from the confidentiality obligation for Equality Act disclosures is just another carve-out from confidentiality. But that's me talking in a drafting sense. What it really impacts is how do organizations settle off these claims? Because presumably, whether it's explicitly discussed or just understood, employers are effectively looking to buy somebody's silence. So if it's the case now, the non-disclosure agreements are unenforceable for Equality Act complaints, then how does the employer feel about that? The potential for somebody to be able to discuss it internally or externally? How does it change settlement patterns? So there's not a timeline for this. So the reason being, as the slide says, this came in July 2025. In terms of the journey of the bill, and the Act doesn't yet say when this is happening, but I think because it's such a big change, it's not likely to be happening in October or April 2026. And I think for HR people on the call, that this is an area where discussing in your team or with management, well, how do we deal with that discrimination complaint because the person can't be prevented from talking about it? Does that change our approach? Now, I don't definitively know the answer to that because at the moment we have some people saying that this change is a retrograde step. That tends to be lawyers that are saying that. And then we have campaigners saying it's a massive step forward. So I think the legal position is this, that at the moment, individuals who are waiving Equality Act claims have the benefit of independent legal advice under a settlement agreement. and therefore they're being well advised on the terms and the obligations, and so therefore they have some level of comfort in this. But I can see for employers it presents a tricky picture, because also the ban on these clauses, it doesn't interrogate whether a particular employee's complaint is genuine or not, or if it's proven or not, or what stage it's at. So if you're being cynical, you could conceivably think that somebody can raise an Equality Act complaint that's spurious, misconceived, made up, whatever, and that they enter into a settlement agreement, and they can still talk about that because they're not prohibited from doing so. And I think probably there is something about the statistical analysis of this. I think the campaigners say, look, people don't just come up with spurious complaints. And if I'm honest, in my practice, it is very rare to see somebody that goes to the extent of making up an Equality Act breach. But it's obviously such a fundamental change. As the slide details, it doesn't affect NDAs for intellectual property, trade secrets, or other commercial matters. So inevitably, there'll be people on the call hearing the kind of headline about ban on NDAs, or maybe you scan it across a newspaper. It's quite a niche exclusion in some ways. It's the unenforceability of Equality Act NDAs, so they can still be used in other terms. So it's a good example of like very easy drafting change for a lawyer to do in an employment agreement, but what's the impact of that in terms of settlement remains to be seen. There's a couple of things about this as well, that it's not just a ban on the enforcement of these in respect of a disclosure that an employee wants to make. It also removes the restriction on an employee talking about the employer's response. So in other words, if the employee says, well, I made this complaint, and then starts talking about the employer's response, that can't be caught in an NDA provision either. So what I would say about this is a couple of things. It applies to employment agreements, so most likely contracts, settlement agreements, and COP 3s. The current statutory rules say that there'll be some accepted agreements. I keep wanting to do this, but accepted agreements, and we don't know what those are, right? But there's going to be consultation on that. I don't think it can be the case that an accepted agreement is a settlement agreement. It's more likely to be the scenario where an individual employee asks for an NDA, asks for that confidentiality provision. That's certainly the commentary at the moment. So it's a really polarizing subject matter. I find it really thought-provoking because I acknowledge in myself that I just draft these all the time, and to a certain extent they get recycled. But as I said a couple of slides ago, it's about the framework of discrimination. Like, this doesn't just apply to sexual harassment. It could be an age, race, gender, disability claim. And then when you look at some of the other changes in discrimination, you can see a tightening of the framework to provide greater protections for individuals.
So with my HR hand, I suppose there's 2 points, isn't there? I suppose it's not just paperwork that we're talking about here. There's probably a really good opportunity to start thinking about how we retrain managers, don't we, and leadership, just to make sure they understand that sort of shift you've been talking us through. Because if we misuse those NDAs or some of the terminology you've been talking about, it potentially creates
there's a couple of things. I mean, there'll be organisations and people in the call that have current settlement agreements with these provisions in there. So, albeit we don't know when the ban on these is going to come in, I cannot think that an organisation can try and now enforce these provisions in the gap until the new law comes in, just because the environment and the morals, if you like, of this have so changed. But organisations might choose to do a hygiene exercise of checking through what do our current settlement agreements say, to make that decision. And then, yeah, for me, it's about the strategy going forward. Like, how do we deal with these claims? What levels do we settle at? What are the risks?
Question in the chat, Jonathan. Does this remove the incentive for employers to enter into settlements or COP 3s and potentially increase the backlog at employment tribunals?
So again,
sorry, just to add, Jonathan, as some of this reason for doing this is to do with reputational risk.
Yeah, well, I mean, this is why we've attached the link to the Can't Buy My Silence website, because Zelda Perkins, who is the lead campaigner in this area, she says that in certain states in America where this has been implemented, settlement is actually increased. So we're not really going to know until organizations start to look at this, and where individuals have professional representation in a settlement agreement, that I do think assists in analysing the risks. And also there's something which I think is a truism, which is when we talk about reputational risk, I mean, Zelda Perkins, the Harvey Weinstein, obviously is like just at the most extreme end of all of this. The scenarios that we might commonly see on a day-to-day basis could be a reasonable adjustment case where somebody's wanted, an ergonomic mouse or some voice-activated software, something that doesn't really carry that, I'm off to the newspapers type risk. But I think there's just a general awareness, because you might still have senior managers who aren't aware of this change and therefore, deal with the situation with the thought process of settlement in their mind. There are still organizations that perhaps have that culture of, we'll buy out the risk. But going forward, this risk is not so easy to buy out. So, it's a good question, but unfortunately, I don't have the answer to the question of if an employee speaks out publicly, can the employer publicly defend themselves? Well, yes, but I mean, as we know, when we get involved in that exchange of versions of events, it can sometimes develop. I mean, I just put it out there, but if organizations are really concerned about reputation, that sits more in the kind of public relations sphere than in the employment law sphere. But yeah, the question about publicly discussing does raise issues of reputation, potentially defamation. It does raise issues in respect of allegations that haven't been proven, and that's why, repeating the word about polarized, you have lawyers that are asking these legitimate questions and thinking, well, how's this going to work? And then you have campaigners saying, well, this is absolutely a breath of fresh air and a necessary step forward. So how that tension's resolved could be through consultation and regulation. So if, for example, the NDA ban is going to be implemented, let's say it's as far away as October 26, there's a bit of time to work through all of these issues. And presumably the consultation will involve employers, ACAS. It might even involve members of the press.
Thanks for that, Jonathan. Just one more question from Kirsten, just before we get into the fire and rehire piece. So what's your views on introducing employment mediation into the tribunal process? Pete Colby, a well-respected mediator, currently has a petition on the UK website calling for a shift in approach. So instead of recruiting additional tribunal members.
Yeah. Well, it's funny. I mean, I've done the maths and mediations that I've participated in recently, and I think for me in my practice, 5 out of 7 of them have been successful. I can't do the maths at the moment. I'm going to call that 75%. But they've resolved in a day. And actually, the interesting one recently was resolved so well that parties managed to shake hands, kind of travelled home together, put the dispute to bed. I do understand that employers can have a view of, well, we're being held to ransom here. But again, the nature of the system is such that claims take a long time to get through the system. And I'm not saying people leave mediation with a good feeling. Maybe both sides feel like they wanted a better outcome. But yeah, there is judicial mediation within the tribunal system. So certainly in Scotland, most of the judges are trained in it, but there's a resource decision about whether the judges think a particular case is worthy of mediation. So yeah, I've started to like mediation after 20 years for that reason. Because listen, the preparation of witness statements, bundles, documents, the risk analysis can be enormous, and because I've had some good results recently.
Henry, just make a note of Sean's question. We'll come back to it shortly. I just want to make sure we get through these big three, and then we'll come back to any questions we've not answered. So we will get back to you, Sean. So fire and rehire, Jonathan, big one. We've all seen it used in restructures. I've had many a conversation during my tenure in HR about this one. But how do these new, I suppose, restricted variations play out in practice? I know we've had many a conversation about this one, haven't we?
Yeah, so with this one, I'm just going to shortly describe the history of it, because I find it difficult just to leap into it with there being so many changes. So the initial proposal in the bill was that there would be a complete ban on fire and rehire, and that it would be automatically unfair to dismiss someone where they refuse to accept a change to their contract. So it's quite a bold move. There was one small carve out where the business was in such financial distress that they had to make changes. So let's say a business was going to insolvency and they proposed that everyone had to have a 30% pay cut, and then someone was dismissed for refusing. That scenario was permitted, but it was really limited. And then through the course of the House of Commons and House of Lords, it became apparent, well, there might be some scenarios where organisations need to use this tool, which is the dismissal and re-engagement tool. And it can provide for a fair dismissal, because basically you've consulted with people, you've explained the changes, you've offered them a new contract. So over the summer, it changed, and I think we've maybe described it as a softening or a moderated position. So Phil's used the right words there, restricted variation. So the variation of terms and conditions and the use of fire and rehire will be automatically unfair, where it's a restricted variation. So these are just the fundamental terms. So if you're trying to use this tool to change, and it's pay, pensions, hours of work, holiday and shift patterns. So these kind of five or six fundamental things. If you're trying to use fire and rehire for that's prohibited and banned, and will be automatically unfair if it results in somebody being dismissed. So that means there are still scenarios where this tool can be used, and there's some examples of that. Might be you could use fire and rehire for job title, duties, location, and restrictive covenants. The location one's interesting. So you can still use fire and rehire for a change of location, and the relevance of that might be the debate around working from home and organisations looking to bring people back into offices. So that's not described as a restricted variation, and therefore it can be permissible under a fair process. So I think I mentioned that one because I was listening to some commentary that said the government's looking to relocate 90,000 civil servants, and therefore it's advantageous to the government in implementing such change that change is permissible and not banned. And that would seem on the face of it to be a reason why a change of location is not restricted and can be permissible. So I think you can, and I'm not doing it now, you can go into the bill and you can look at the 6 different heads of restricted variation and know that they are automatically unfair if you try to dismiss someone for refusing to accept. But it is just the bigger, more fundamental items like pay, hours of work, pensions, holidays. So it's a softening of approach. I think in practice, employers tend to use this tool as a cost-cutting tool before looking at redundancies. So potentially some organisations might move more swiftly to redundancies. I think I said at the start when we looked at the roadmap that the key practical piece for this is to have a variation clause in your contracts that enables you to make changes and to get that clause in to the contract before October 2026 when fire and hire is banned. And the reason for that is within the legislation there is an anti-avoidance measure that won't enable employers to put a variation clause in after October 26, otherwise that would defeat the whole object. So Phill and I can help with drafting these clauses, which are literally 4 lines long, and just say, the employer in good faith, reserves the right to change terms and conditions on reasonable notice, and will do that within one month. And if it's a fundamental term, we'll consult with you. It just gives some coverage. So we front-ended the description here to talk about the ban on fire and rehire, but to a certain extent, you can circumvent that a little bit by having a variation clause and relying upon that contractual term. So necessarily,
examples where
yeah,
getting stuff done sooner rather than later is key, isn't it? You know, HR needs to get a little bit smarter, don't they? So stop leaning into that fire and rehire as that quick fix and just get stronger variation clauses like you suggested, just locked in now before the change next year.
Yeah, I think if you left it till August, September next year and you send a memo around your staff saying here's the new clause, it's going to be very obvious why you're doing that. And I guess, truthfully, that can be unsettling for staff because they're thinking, right, well, why is this clause being introduced? That's because they're going to look to change some of our terms. So I tend to avoid saying this in seminars, but it is truthfully the case that on that question of variation clause, there will be case law around the interpretation of it, because the whole legislative framework is to prevent that happening. So it seems that me proposing a variation clause as a cure-all, I think in the short term, yes, but I wouldn't be surprised if there were developments to follow to stop that.
Question in the chat, Jonathan. By hours of work, is it the number of configuration of the working hours? The only time I've used this in the past was to change the working pattern to better meet service user needs and occur at home service. Hours per week remain the same. Would this still be okay?
I would need to actually get a pen and note down hours and configurations and work this through. But I think the restricted variation on hours is actually pretty well drafted, such that we cover both changes in the hours of work and the configuration of the working hours. I can double check, and I can get back to Michael, who I know pretty well. Yeah, I mean, it does say also that the restricted variation is a variation in the timing or duration of shifts. So I think, Michael, that does cover the prohibition on varying hours of work and the duration. I think it was the word configuration that threw me there. I've not heard that one in a while. But yeah, I think it's both, Michael. But I'll come back to you later on.
Great, good question, Michael. Thank you for that. Shall we spring on to the next one, Jonathan?
Yes.
Yeah. So I know we've had quite a lot of questions pre-session in regards to family leave. So do you want to similar approach, Jonathan? Talk us through what's coming. We know about the menopause action plans, extended bereavement leave, the pregnancy protections that we've talked about on the timeline slide, but anything additional you want to sort of talk through position with the group?
Yeah, for sure. Yeah. So, well, first of all, really positive to see the framework of family-friendly legislation improving. And as I said before, some organisations will be going over and beyond the statutory levels anyway. I'll start with pregnancy protections. I mean, thankfully, in the last 5 years, I would say I've not had any scenarios where I've been dealing with pregnancy or maternity dismissals. So the main current protection for pregnant women is that they have the right to be offered suitable alternative employment. So if someone goes on maternity leave and there is a redundancy exercise, then the pregnant woman has the right to be offered and doesn't need to attend an interview process. Obviously, in real life, there can sometimes be a discussion around, is that really a suitable alternative employment? What else is an offer? And there can be sometimes settlement agreements that come out of that. So that's the main protection currently, but there are still scenarios where pregnant women and new mums are dismissed. I stumbled over my words there because it's so abhorrent, right? But such a horrible situation. But basically, the extension of the pregnancy protection is that employers will be banned from dismissing pregnant women and new mums in the first 6 months after birth. So it's a really bold protection. There are suggestions that there'll be regulations to follow that say in certain specific circumstances it might still be allowed. So presumably, if a returning mum commits an act of gross misconduct, there must still be the ability to dismiss. But it just very much strengthens up the protections. I suppose when I look at this and I think back across my experience over the years, there probably have been restructures where somebody's recently returned to work and where they've accepted the scenario just because, they're adjusting back to work or possibly cultural issues. So there'll be a prohibition on dismissal for pregnant returners for the first six months, and there's going to have to be regulations detailing of all of that and what that looks like. So yeah, I've mentioned that one because it rarely happens, but it's good to see greater strength in that area. I mentioned paternity.
I agree that it rarely happens, but I probably had the conversation over my years in HR too many times. So I'm all for that. It's a good positive step in the right direction, isn't it?
Yeah, listen, for me, it's just really weird when you're speaking with somebody and that's the outcome that they've come up with, especially acknowledging that maternity pay in the UK is pretty rubbish. So, if somebody's off for 52 weeks and I'm trying to recollect, but from week 33, 36, they're on statutory maternity or less than statutory maternity pay. It's awful when these scenarios develop. And of course, it's the classic scenario where the employer says, "Oh, actually, we've realised we didn't need that person whilst they've not been here. We've managed to cope okay." But yeah, it's a rarity, but still good to see the additional protection.
Agree.
And yeah, menopause action plans. So I looked into this, and the Women's Inequalities Committee developed some research into this area, which indicated really bold statistics, like 60% of women who are affected by the menopause end up leaving work. So I'm saying obviously just because I'm a man, but I don't recollect in my time at work having these type of conversations. It's a really pertinent and an important issue, and looking at the levels of people that are impacted and the fact that they can't commonly talk about it, or maybe they don't have support or reasonable adjustments. The Menopause Action Plan, which is mandatory for employers with over 250 employees from 2027, is a step change. And somebody might ask me, what does that action plan look like? And I'd have to say, I don't particularly know, other than the key discrimination messages around potentially making reasonable adjustments, potentially having menopause champions, having support in place, just general management training and awareness of the impact. These action plans are voluntary from 2026. So I'd imagine if organisations are looking at their family-friendly legislation, then it could well be the case that they look to implement these menopause action plans.
It's certainly something that we're encouraging. The UK is not slightly very behind the curve in terms of policy, support, training, education around menopause, whereby we work with quite a lot of global clients in different countries, whereby they've already got locked in things like you said, dedicated points of contact, great training, great policies, great support. So it's a great step in the right direction, but we are still somewhat behind the curve if we were to compare ourselves to other countries who already have this sort of stuff.
Yeah, listen, I totally agree with you. The fact that I'm struggling to use the correct language reveals that, and it's pretty awful that I've not, my 25 years of work had conversations around the impact in that area. So we put bereavement leave on there. The slide kind of speaks for itself in terms of the extension for miscarriages, in terms of where the miscarriage occurs before 24 weeks, then individuals will be provided with unpaid time off. It doesn't currently stipulate within the Act how long that time off is. And when I see the word unpaid, I always think the same thing, which is this is a new piece of legislation. It tends to be the way with family-friendly leave that for whatever reason, when they're newly introduced, it is unpaid, and then a year later it becomes paid. It does seem a little bit tight because all of the legislative commentary talks about the impact and grieving process. And of course, for some people, that's compounded then by not being paid. So I'm personally, taking off my lawyer hat, I'm not always that comfortable with the idea of, hey, great news, you get this family-friendly leave, but don't think you're getting paid for it. So, I mean, that is an example where I'm going to say an enlightened organization, a good employer might say, well, we're going to pay you for the first week. I know all of these things have costs. I'm aware organizations are reporting about the increase in national insurance and other costs. For sure, some organizations can lead in that. I think within the legal sector, definitely certain law firms have really promoted their family-friendly leave and how generous it is as a recruitment tool. So that's broadly the changes. I think in terms of impact, it's very easy for me to say these are just changes to policy. I suppose there can be a communication exercise that supports it around being a family-friendly organization. And I think probably in terms of the headlines there, the main thing is to keep an eye out around these pregnancy protections and how the regulations might enable employers still to dismiss, because that's to follow.
That's good, great.
Yeah.
Good, Jonathan. Really, really insightful. Gwen, we'll come back to your question. We might just need to follow up on it after this call. But Henry, just make a note of the question from Gwen in the chat, if you don't mind, please. So I suppose that sort of lends it nicely into the how can you prepare, Jonathan, doesn't it? So I suppose if we're thinking about contracts and policies first, for an employer, and I suppose quick question and answer time. If an employer hasn't touched their templates in years, which typically is the case when we speak to people, what's the risk?
Yeah, well, I think there needs to be a variation or consideration of a variation clause so that you've got that tool of fire and rehire if you wish to use it. I think the sexual harassment area, because of the Worker Protection Act last year and developments under this new act to follow, that's an area to really look at and see whether the correct language is being used. So some employers are extracting that out as a standalone policy. And then family friendly we've discussed, and the question about the communications around it, because some employers will just say, they'll have a provision of family friendly, and it'll say we give all such family friendly leave in accordance with legislation, which is pretty dull. But I mean, there's an opportunity here to update and to explain and sort of positively position those changes.
Training managers. So what happens if managers aren't trained and perhaps end up getting stuff wrong? So if we talk about the dismissals and some of the things you've talked about, naturally know what's going to happen. Well, what advice would you give there?
Yeah, so I think it's what I said about the power of HR. So, because I'm so immersed in this area, there's times when people issues are kind of higher up the agenda. So for me, right now, people issues should be top of the agenda, and training your managers could be around explaining, for example, that we can no longer just buy out the risk of a discrimination claim and expect that to go away, because there might be managers, let's say in an organization that's got some remote managers, where the management isn't aware of that. So I think that's kind of, I don't know if to call it like good reporting, but just making sure that there's an understanding that these changes aren't just updates, they'll impact strategies.
And then I suppose on the review of the workforce models, employees relying on 0 hours or casual contracts, I suppose that's something to consider, isn't it, and think about.
Yeah, for sure. So we haven't touched upon 0 hours workers and guaranteed hours and the right to request or the right to be offered guaranteed hours contracts, but definitely in some sectors, that's going to have quite a big impact. And my understanding of that, obviously I might have to follow up separately, is it's really complicated to actually calculate averages of hours and to apply that in practice. And I think there's a lot of time that you know HR teams can be drawn into in terms of managing that. And yeah, it can change labour models, as the day one unfair dismissal rights for employees might do also.
And I think we've covered off the strengthening of the dismissal processes on some of the prior slides, haven't we, Jonathan? And you know, preparing for claims and requests. We touched on the ACAS piece that we talked about, and we've had a couple of great questions from the audience as well. So how about we sort of open it up to the floor and see if there's any questions from anyone else. So I know we had one previously from, I think it was Sean, wasn't it? If I remember rightly. Yeah, so is there an argument where ACAS, WFA take the lead in adjudicating in minor/clear breaches of the ERB, soon to be the ERA, where the evidence provided doesn't reach a set threshold to defend a claim, an allegation, similar to that set out by the CPS? This could reduce pressure on the ETs.
Yeah, I mean, there's some jurisdictions where they have a form of pre-hearing review where a judge sort of says to the parties what the relative strength of their cases are. So I'm told in Australia you have these hearings where a judge gives a strong steer. We don't have that in the UK. I think the difficulty with ACAS is that they are a statutory body, and so their governing structure is in accordance with statutory rules, and so they don't currently have those powers. So you might say, well, how can ACAS powers be changed? Well, they're not legally qualified, so probably lawyers have done a good job of preserving this work as being, you know, required to be done by lawyers. So I'm not sure. I haven't read any commentary about ACAS's powers being extended, but I've read a lot of commentary about ACAS resources needing to be improved with more people. But you know, the employment tribunal model for me has been the same for the last 20 years, so with some minor tweaks. So nowadays a judge can decide to hear a case on their own, which is as compared to a 3-person panel, and you know, some moves to judicial mediation. But I think it would be very expensive for ACAS to be funded to take on board additional responsibilities.
Cheers, Jonathan. We've just got, I think that's all the questions in the chat. If you've got any questions, guys, just drop it in the chat or raise your hand and we can get through them. But a couple on the slide, Jonathan. So are these changes guaranteed to happen? So we know some of them are already locked in and some of them are going to happen, but in the likelihood, it's more likely than not, isn't it, that these things that we've talked about are going to get locked in?
Yeah, so I mean, I had to do a bit of reading on this or learning. So yeah, it's called the Salisbury Convention. I don't know if John's still on the phone, but anyway, if you look it up, it basically means that when a piece of legislation is going for its third reading at the House of Lords, it has to be accepted as drafted. So there aren't going to be any further House of Lords amends. So for sure, you'll have some commentators still talking about the bill, and that's correct. But when it goes back to the House of Lords, they are duty bound by convention to just endorse it. So all of the changes that are in there just now are going to happen. When we talk about regulations and codes of conduct, that they're not going to counteract that. It's just about implementation. But for sure, there might be some small adjustments to follow. But again, it's a landmark piece of legislation in the Labour Manifesto, so it's kind of going to happen shortly.
Cheers, Jonathan. I've just got one last question in the chat from Gwen. If you could just read over that, Jonathan, and then I'll just move on to the summary slide, just while you ever think about that particular question for us, and we'll go back in a second if that's all right. So I'm just conscious a lot of people are dropping off now. No, the end of dinner or end of time, but I suppose to wrap up session today, it's the reform rolls out in phases from this autumn through to 2027. So just bear that in mind, and that's clearly what Jonathan's walks us through today. April 26th, big milestone, day one rights, whistleblowing redundancy. So bear that in mind. the big three shifts, ticket items that Jonathan and I walked you through today. So the NDAs, the fire and rehire and family leave are really important. And the bill's much more around just compliance, isn't it? There's a huge cultural shift in the positive sense around fairness, predictability on hours, employee voice, embedded into the workforce. So lots of things to think about. But I suppose if you had to think about one legal watch out, Jonathan, based on everything you've talked us through today, what do you think that would be? Key takeaway
Okay, easy, put me on the spot.
on the spot.
So I mean, listen, for me, I think it's only in the last few days that I've kind of tied up in my mind the Worker Protection Act on the preventative duty for sexual harassment, the abolition of NDAs, which impact sexual harassment, and then knowing the Employment Rights Bill in 2026 is talking about all reasonable steps to prevent sexual harassment. So for me, that's like a risk area, because when these cases happen, they can be quite contentious and costly. So that's a thread, if you like, through the legislative programme that I kind of only saw the different pieces coming together when I was preparing for this session. So I think trying to be a stronger employer in fields of equality and discrimination, it's obviously the right thing to do, but it's a very strong risk measure. And I don't think it's that well reported in terms of all these changes. If you think about them, there's hundreds, but the sexual harassment piece is now linking across numbers of pieces of legislation. So I think yeah, if I use language of watch this space, I think we'll start to see how that all knits together.
Great. Cheers, Jonathan. Terry, Sarah, yes, we'll send a copy of the slides after. Don't worry if you missed the start. We'll get that content out to you, and Henry will sort out recording of the session as well. So just quickly getting back to Gwen's question, Jonathan. So I have 5-year employment contract and a revenue-based bond in my salary as CEO. Attached my employment contract as CEO of this biotech company startup in London. Could the business owner, having also a branch in the Netherlands, once in the reception of funding in the Netherlands, avoid to paying me because my contract is with the same company, but in the UK, even though I am the CEO of business activities globally? Sorry, mouthful for me.
Yeah, I don't know if Gwen wanted that as a private question or as a general question for everybody, but I mean, what to do is look at the jurisdiction clause in your contract, and that tells you where you should raise any claim if you're not paid, and then that can be enforceable. So I think from what you're saying, that could be a London contract, in which case you have the right to raise a claim there. Of course, raising claims it's not always the easiest or the nicest option to do, but I suppose Phill, you can comment on this, where there are international organizations. I've not really seen the design of international organizations as being about avoiding paying someone in a different jurisdiction. So, if you're comfortable with your contract terms and you look at the jurisdiction clause, that's the initial starting point.
Yeah. Yeah, maybe a separate conversation after the call. We're more than happy to set that up. I think we've got through all the questions in the chat, Jonathan. So just quick slide on how we can help you plan and prepare. And I suppose Jonathan and I have talked you through some of this stuff, but so before we close, at Briars, we're focused mostly on the HR side, so we can help you review and update contracts, handbooks, policies, terminology. We can help provide manager training and embed cultural change if it's required. And then on the ongoing HR support as well, regardless of country as well, we can help with each reform as it lands according to the phases that Jonathan walked you through. Jonathan, from the legal side, from a level point of view, where do you see businesses needing the most help? And I suppose time for you to plug level law here in terms of all the great stuff you do in terms of supporting businesses going through, pretty seismic change, similar to the ones you've talked about today.
Yeah, for sure. I mean, I suppose I'm a dispute specialist, so if organizations find themselves in a scenario of claims or threatened claims, then I'm very well versed in that in terms of managing them and the timeframes and the risks and the tactics. So on the compliance side, I'm always happy to help work through what that looks like. I think HR professionals do need support. I mean, there can be resistance within organizations around these ideas, such as me saying, make more beneficial family-friendly terms. It's kind of quite easy for me to say, but there's a cost attached. So yeah, I'm more of a litigation specialist, but I'm pleased that we've managed. I'm honestly genuinely pleased to share that roadmap. Many of you have seen it before, but it just helps because it's not overwhelming here. We've got 6 months till April at least, another 6 months. So this layering or phasing in, I think really helps. So yeah, always here, happy to chat.
Great stuff. Cheers, Jonathan. So I suppose last thing for me, just massive thanks to everyone who's joined today. Thoroughly enjoyed the conversation. Thanks very much for your time again, Jonathan. Really insightful, really informative. Yeah, final thought, I suppose. Yes, we've got time in the bank, but let's not wait for deadlines. I think there's some really great stuff we can sort of get moving on now. So use this as an opportunity to sort of modernize some of those policies and cultural aspects that we've talked about today. Henry and team and I and Jonathan will follow up with resources for those who missed it or just want to reflect back on the deck or the recording. Details on the screen if you want a conversation afterwards. But yeah, amazing session. Loved it. Great to see you all again. Newbies, people we've met previously. So have a great afternoon. And again, Jonathan, thanks very much. Appreciate your time, effort, and commitment to educating us all on this good session.
No, super. Thanks, everyone. Have a good day. Cheers now. Bye-bye.
Take care, all.